Well, you're not going to believe this, but just before I was all set to do this video on a recent update that the Land Registry has just made, I found a court ruling on electronic signatures when using your emails. So I want to share that High Court decision with you before ending this video, as it is a bit of a surprising outcome. So the Land Registry has updated their requirements on using digital signatures for deeds. I will also discuss the pros and cons of using vendors who provide services for creating digital signatures. If you're interested in learning something you may not know, then stick around for the next part of the video. For those of you who are new to my videos, my name is Karen Cole, and I'm from Legal Minded Friends, and my aim is to assist individuals or businesses who represent themselves in a legal matter. You can read more about me on my website, which I have left a link below to in the description area. So let's get started. If you are in a financial negotiations due to separation or divorce, you may be selling your property or transferring a jointly owned marital property. This will no doubt involve the Land Registry. So in October 2021, the Land Registry gave an update on their digital roadmap services, as it had been 5 years since increasing their investment in digital services. The aim is for them to move to digital applications online. So they are looking to technology to market, understanding opportunities for digital signatures, and proving identification. I have left links below if you want to read documents that they do accept by way of qualified electronic signatures, as right now they are extending the pilot scheme Sign My Mortgage digital service. The benefits to digital signing is it will increase speed in processing. There will be enhanced security, and ultimately this will lower the transaction costs, as there will be no need to photocopy or post. The online documents have areas which highlight mandatory places where you will need to sign. So this in itself prevents delays, because the form will have exactly where you will need to sign on it. The digital signatures will have automatic timestamps, so the audit trails will be easier to track. The Land Registry has updated their requirement process on the 9th of August 2021. The Land Registry does accept some deeds by electronic signature, and it is the conveyancer's responsibility for setting up and controlling the signature process. So what's the downside? If you are a conveyancer using a vendor that provides electronic signatures, make sure your documents are not stored on the service provider's memory. So that would be a good question to ask them if you have control of that process. The other issue to be mindful is that all people involved in the process must agree to the electronic service. If you're concerned about fraud, then make sure the Land Registry has your current address. If you are no longer living in the property, that you own, because this is important as the land registry will contact you if there's any activity on the property. Before ending, I promised you I would share a decision by the High Court, and this is for people who have generated an automatic reply with an electronic signature on their email account. This is also known as a footer, where your signature goes above your address at the end of an email. So, a couple of years ago, the judge ruled for the claimants, who argued that after a phone call confirming with the defendant regarding the terms of a settlement in a land dispute, the claimants followed up with an email confirming the terms of the conversation. The defendant in this case sent a reply simply writing, "Many thanks." They, the claimants, took this to mean that the terms of the contract were accepted. The defendant, who is the person who wrote "many thanks," said it was not accepting the terms of the contract, but simply thanking them for the email. But because the defendant had a signature, they took this to mean it was an official acceptance. The judge ruled for the claimants, saying that an ordinary person would consider that when a sender stores their name in the signature function on emails, they would do so intending to sign every email. And now I'm cutting a long story short, but to have a signature gave the assurance that it was official. So to avoid this, make it clear on the email footers that your salutation signature is not intended to stand as a signature, or avoid having a signature in the first place. There are many electronic signature apps, so think twice before using them automatically, as you may be unknowingly agreeing to something you didn't mean to agree to. Now, the defendant in this high court case was a solicitor. However, you can legally do your own transferring of deeds, and the land registry does allow you to do so. So I think this information is relevant. And check out the land registry blog.gov.uk, where the head of customer policy and services discusses conveyancing, solicitor, or DIY. All links are in my description area below, and you can read real people's questions and experiences with the land registry. So check them out. Well, I hope you enjoyed today's video. Please like and share, as you never know who it will help. And if you have a legal worry, contact legal-minded friends. Thank you.